Hi, everybody, and welcome to a very special episode of Unleashed. We are live right now, live. So as you're listening, if you have questions, please throw them in the comments. And if you're a hater, I'm going to ignore you. So I get to say something very cool today. I get to say, we won. We won. After what seems like forever waiting for the Supreme Court decision to finally be announced. It was announced today on the last day of June, and June has been declared Title IX month by the Trump administration and the Secretary of Education, Linda McMahon, and the Department of Education. So what a great way to end the month of June, the second annual Title IX month, with such a historic landmark win. And I have with me the president of Southeastern Legal Foundation, Kim Herman, because we all have a lot of questions, and I want to be sure that the answers that we provide are factual. I don't want to give a pie in the sky approach, nor do I want to be a Debbie Downer, like, oh, well, this doesn't apply to 23 states, so woe is me. So I want to get a real take from an expert and somebody who has been in this fight for a long time. So Kim, let's just bring you on the stage right away. And we're going to celebrate, because we have to celebrate the wins. And maybe it's not everything that we wanted, but this is a big win. So I want to take this time to celebrate and to thank you and Southeastern Legal Foundation for all you have done in advancing the cause. Oh, Kim, I can't hear you. Hold on. 1 second. See, this is when you're going live.
I think that was me.
I hear you now.
I was moving. I have so many papers on my desk this morning that I accidentally hit mute. So apologies. I was just saying thank you to Moms for Liberty for being such a great partner and a client in some of our other cases. But today is the day to celebrate, like you mentioned. We'll parse this opinion. We can dissect it all day long, but today is a day to celebrate. Huge win at the Supreme Court, who unequivocally said today that sex means biological sex.
Yes, that was part of the opinion. That's a big takeaway. Quote, sex cannot plausibly be interpreted to refer to anything other than biological sex, end quote. So what does that mean? What are the implications of such a strong statement?
Yeah, so before we get to the implications, I just want to frame up for anyone that's maybe just tuning in, or you kind of know that there's this fight about girls sports and keeping boys out of girls sports, but frame up what these lawsuits were about, if I could just take that liberty for a second. So what was happening in these two lawsuits, where we had West Virginia and Idaho, and they passed laws saying that biological boys cannot play in girls' sports, or biological men cannot play in women's sports, because they apply to college also. And we had two individuals, one in West Virginia and one in Idaho, who filed a lawsuit saying that these laws violated Title IX, and that these laws violated the Equal Protection Clause. And so specifically what the court was looking at here was whether or not states can prohibit boys from playing in girls' sports. So just want to kind of frame up the issue that was before them. And the court came down today and said that, yes, if a state wants to say that boys cannot play in girls' sports, they absolutely can do so, that it does not violate Title IX, and it does not violate the Equal Protection Clause if they want to ban them. And so 27 states have similar laws to this.
Yes. Okay, then that's a good frame up. So now we get the decision. Kavanaugh writes the opinion, and I have a lot of questions. I'm going to be going through my own notes too. So we said this in the beginning, that sex means biological sex. Were you expecting a strong statement like that? Is that a surprise, a good surprise, or what you were expecting?
Yeah, I mean, I think that after the oral arguments, that many of us who kind of follow these cases and follow the Supreme Court we were expecting an opinion along these lines. It's really important that the court very, very clearly say that sex means biological sex. Because that means that if sex meant gender identity or if sex meant transgender status, then this may have come out very, very differently. And the court was very careful here to make clear that gender identity and transgenderism, or whatever you want to call it, is not protected under the Constitution as its own class, right? The Constitution says that you cannot discriminate based on sex. Title IX says that you cannot discriminate based on sex. And these laws don't discriminate based on sex. And we can walk through kind of what that means and why they don't discriminate based on sex. But we have to first have that definition, right?
Yes.
Because you have competing parties, you have competing interests in this country. We had the Biden administration that changed what sex meant in Title IX, and we stopped that. So that's the framework for everything here.
The framework, yes, the definition of biological sex. Does this help Congress? Because we also want Congress to define biological sex. That's still important.
Yeah, I mean, so what the court evaluates, and it really spends time going back to what did Congress mean in 1972 and what did Congress mean in 1975 when it amended Title IX to add that it specifically applied to sports. And it says that if you look at the meaning at that time, Congress meant biological sex. And so would I love to see Congress come in and put a definition in Title IX? Absolutely. But with this opinion, we don't necessarily need it to now. We have the precedent now to go forth and build on other cases. And this is really going to cabin any future administration who wants to change the definition of Title IX, because the Supreme Court has spoken on it. So we cannot go back and have another, Biden Title IX rule in the future, if you will.
So if there's another administration, and this would be not good, but if there was a Democrat, that wins in 2029, and the first thing they want to do is change Title IX, they'd be prohibited from including in the definition of sex, as per Title IX, gender identity, because the Supreme Court is law of the land and they have spoken. So this gives real long-lasting protection.
It does, right? And Title IX is passed by Congress, but what we have is the Department of Education that's interpreting it. And so the Department of Education cannot come in. If Congress wants to go in and change the definition, it certainly can. And I haven't been following, what's happening out there. I've been reading the opinions, but I'm sure there's already calls from those on the left to do that, right? Where they're going to already be dropping bills and such to say, well, no, we want to change the definition of it. But there's some great language in the opinion that makes it really clear that, that ship has sailed essentially for the left.
And this people have been calling this both a 9-0 decision and a 6-3 decision. Can you kind of untangle that for us? What does that mean?
Yeah. So when the justices issue their opinion, they can do a variety of things, right? They can say that we agree in the ultimate outcome of the case, but we don't agree in the reasoning of how they got there. And so with respect to the Title IX challenge of this, which was the focus of one of these cases, we saw all of the justices agree that the law did not violate Title IX. When it came to the Equal Protection Clause piece of this, we saw 3 of the justices that said they didn't think the court should have ultimately ruled on it. They didn't think that there were enough facts out there to apply to the constitutional standards. So in other words, did it meet the level that it needed to meet to pass constitutional muster, if you will? And they would have kicked it back down to the lower courts. I will tell you, the dissents are full of a lot of rhetoric. Notably, the majority opinion is not. And so it is very straightforward, takes out all of the politicism of this. The dissents tell a very different story.
Okay. And now they talk about the 1974 Javits amendments. I don't have my glasses on. So what is that?
Yeah, so Title IX was passed in 1972, and the purpose of it was to ensure that everyone had an equal opportunity in education and that schools weren't discriminating on the basis of race. In 1975, we saw amendments that applied it to sports. And sports really is the focus of this particular lawsuit here. The majority opinion goes into great detail talking about competitive fairness and talking about safety, especially when we're looking at the Equal Protection Clause claim, because the states have to show that there is a reason for passing this law, right? I'm going to try to keep all like legal jargon out of this, but they have to show that there's enough of a reason that they needed to pass this law. And here, that reason is safety and competitive fairness. And so the court spends a great deal of time talking about that.
Yeah. Then I want to talk about this. They talk about skirmety.
Mhm.
What is the importance there?
Yeah, so the Scarametti case was a case out of Tennessee where we saw the state essentially banning. Oh my gosh, I'm drawing a complete blank on the word right now, but banning gender transitioning essentially for minors. Some of the medical procedures and such that can happen. And there was a challenge against that, and that law was able to be upheld. And so the court leans on that to a degree with respect to the fact that transgender status is not protected by the Constitution. So sex means biological sex. We even see in a really strong footnote here saying that the Constitution does not require the states to essentially look at gender identity, but rather biological sex. And so it builds off of that case, just like we're going to have future cases that build off of this one. That's why we need to have all of these wins at the Supreme Court.
So, to people over the moon today, those in the 27 states that have laws on the books that protect women definitively, that have already banned males from participating in female athletics, they're celebrating. Is this more durable than an executive order? Because there's those of us that go to our school board meetings and we'll cite, hey, President Trump issued an executive order. There's guidance from the Department of Education. You should listen. Is this decision more durable? Not only just those 27 states, but in the 23 states that do not have those protections in their state law?
Yes, I would definitely argue that a Supreme Court ruling saying that states can ban boys and girls sports is much stronger, if you will, than an executive order. One, it's going to stand the test of time. So getting a Supreme Court case overruled is a huge endeavor, right? We saw this with Roe v. Wade and the Dobbs opinion. It can take decades and decades, and it only is going to happen if that opinion is based on bad law. This opinion is not based on bad law. This is a solid opinion. And so for the people in those 27 states, this ensures that your state law is going to stay on the books, essentially. For those in the 23 states, it means that with respect to sports, you're going to have to keep fighting. If you look at this case and like the case that we won in Kansas when we were fighting against the Biden Title IX rule, there the court said, and I've got it pulled up to make sure, it had been a while since I read the opinion, but the court made it really clear there that changing the definition of sex exceeded and would have violated Title IX, the actual law. And so there's argument and room here that states that allow boys to play in girl sports and they're violating Title IX. So it's not just going to be our administrative complaints. We can use these cases together and go fight in federal court.
That's awesome. That's amazing. I for one, I am very happily surprised to see these definitions and a strong, firm case made that sex, as per Title IX, means biological sex. It's unequivocal. I mean, I think slam dunk. I know that there's going to be lawyers from the left that are going to find a way to challenge this, but I think this is a pretty strong case, a strong decision. A question for a lot of those who aren't legal eagles. There's one decision. Did the court combine the two cases and into one decision?
Yeah, so the court had heard these cases together and it issued the opinion together. And so this is essentially going to be known in the future as B.P.J. That's what people will refer to it as, just like like I said, the Dobbs opinion, or there was a totally different area of cases yesterday, this Humphreys executor case, and that's how everyone refers to that. That got overturned and is done. So yes, one opinion. But there are the two parts of it, Title IX and Equal Protection Clause, ultimately the same ruling, but these will offer different avenues and two strong avenues to go forward to ensure that we keep boys out of girls' bathrooms, locker rooms, and sports in those 23 states.
Why is it important that they address the Equal Protection Clause?
Yeah, so Title IX can be changed, like we were talking about earlier. It's a law passed by Congress, so Congress could come in and they could come in and say, you know what, we really meant that sex means gender identity, or that's what we mean for it now, and so we're going to amend the law and change the definition. I mean, plausibly, that could happen. That's the way our government is set up. We have the Equal Protection Clause in our Constitution, so unless you get a constitutional amendment, we will always have that equal protection clause. And so it gives us that additional level of safety and security here to know what sex means. And if Congress did change any future definitions, then that would arguably violate the Constitution. So it's kind of this circular thing, but it gives us that additional layer of protection, which is why we fight for our Constitution every day.
And it's really important, right, that gender identity is not equivocal to race, to sex, as far as getting protected under the law. Because if that weren't the case, I mean, we'd be done for.
Yeah, I'll tell you, there's so Justice Thomas issued a separate opinion, and I always love Justice Thomas's writing. And it is, I'm looking to see, I had it flagged here. He makes that really clear. Now, obviously, this is not the opinion of the court, but it's really interesting language. And he unequivocally says that transgender status is not a suspect class, that it is mutable. So he says that gender dysphoria is a mutable mental state. And he goes on to be very, very clear that sex is immutable. So he makes that distinction between gender identity being something that people can change and sex being something that people don't change. And that's why it's protected the way it is in the Constitution. It is a 2-page concurrence. For anyone out there, I strongly recommend that you read it. It's a great 2 pages.
So there's purple states where this is a political football. I'm in one of them, Wisconsin. And we have blue states where you've got some leaders dug in. They are dug into the trans agenda. They right now they're in open defiance of federal law. How does this affect Illinois? How does this affect California, Vermont, Maine? So many.
Yeah. Well, I mean, there's a lot of Title IX investigations already going on. So you're going to see those continue. And now the Department of Education isn't going to have to get that pushback in the courts. And so against about what sex means. So when they ultimately come in and say, hey, I don't know, Colorado, right?
Yeah.
Colorado.
Jefferson County.
Yeah, whatever the county is. I was trying to think of a school that's under investigation. There's so many of them right now. I couldn't pick my favorite. But they say, you violated Title IX, and they ultimately have to bring an enforcement action. If the school wants to argue or the state wants to argue back, well, no, Title IX, sex means gender identity. They can't do that anymore. So it's going to cabin the arguments that they can bring in defense. And it's only going to give those of us who bring these proactive suits an avenue forward as to bringing them.
I find it interesting. I'm actually going to be talking to a dad in Michigan. His daughter is in a school and one of the schools that is now under investigation by the Office of Civil Rights because they allow males onto girls' athletic teams, in bathrooms, in the locker rooms. And he sent me something sent to him directly from the school board that said, well, we're not going to change anything. We're awaiting, Supreme Court decision and the results of our OCR investigation. So they're essentially, they're trying to say, oh, we're trying to follow the law. We're waiting. We're waiting. Well, now that this decision has come out, and now that it's pretty clear that OCR's got to be even firmer argument to say basically you aren't in compliance, and we're going to move to enforcement. This is pure speculation. I wonder, what are these school districts going to do next? I mean, they have pretty shaky ground before. They don't really have a leg to stand on, and I'm wondering what they're going to do next.
I mean, I know what we're going to see. We're going to see them say, well, this only relates to sports, and it only relates to states that are banning boys and girls sports. It says that it doesn't reach other situations, right? And it does. And we have to be fair about what it says, right? The court said that it is not necessarily issuing an opinion that says that states have to ban boys from girls sports. It's just saying that they can do that. But again, by giving us that definition, I know I'm probably going to sound like a broken record by the end of this, and in the days and weeks to come, but by giving us that definition of what sex means, now when the Department of Education comes in and they enforce Title IX against these schools for violating it, there's not a question about whether or not it reaches gender identity. There's not a question if the standard's subjective. We know it's an objective standard. And so we know that they're going to argue that, and it's going to be a fight, and parents are going to have to keep standing up, but the law is on our side.
So why did the court say that? A lot of people question, why did they say they can? Why didn't they say they must? They had such a strong definition of sex. They defined sex by Title IX to include male, female, could only be that. It's only biological sex. Gender identity isn't protected by the Equal Protection Clause. And then they said can and not must. Why?
Yeah, well, where they really can only rule on what's before them, right? And so this is something that I know it drives everyone nuts, but at the end of the day, we really do want these protections in place, because this is how our judiciary is meant to work. They can only rule on the case that's before them. And what was before them was a challenge to states that said boys can't play in girls' sports. It wasn't a challenge to say, can a blue state allow boys to play in girls' sports, right? It wasn't a challenge by a girl who had been physically hurt or a girl whose privacy interests had been violated. And so those are going to be cases that are certainly going to continue to work their way up. There's some bad case law on the books from back during the Obama administration in cases like that. And so now new cases are going to have to be brought. We have to bring cases in the Fourth Circuit, in the Third Circuit, get that bad case law. In Wisconsin, Wisconsin's in state court, right? And I'm thinking more federal court, but yes, in our state courts too. And we have to bring those cases to get those bad cases overturned now.
Yeah, and I'm going to talk to Wisconsin Institute for Law and Liberty later and ask a little bit more Wisconsin specific things but yeah, we've got some bad case law that we bump up against. But I see, having gone to these school board meetings, having been at your side when we were fighting back against that Title IX rewrite, boy, did I get to know and how to argue against some of our bad. We don't have in our state, in Wisconsin, thankfully, we don't have written into statute a definition of sex that includes gender identity, but it doesn't necessarily say specifically male and female. So people have been trying to interpret it the other way, when I think, just like with the Congress in 1972, they meant sex to mean male and female. They just used the word gender a lot back then. And I actually looked it up. The reason why, because they weren't comfortable saying the word sex. That was a big part of it. They just weren't comfortable saying the word sex. So they said the word gender because it
Okay.
was just a different time, and especially a lot of men just felt really uncomfortable saying that word out loud. So
We hadn't
they,
had 80s and 90s hip hop yet where we
yeah,
were.
yeah, they weren't, it's really, I found that fascinating, but I could relate. Like our
Yeah.
grandparents just didn't want to say that word, so they used the word gender, but it meant male, female. It didn't mean the thousands of gender expressions. That is completely made up. So just a little fun fact if people wonder
Yeah.
why did they say gender.
And it is. I mean, and that, and it's again, I think the next frontier are going to be those cases, right? So it's going to be really focusing in on where is it that we have that the bad case law, essentially, especially when it comes to bathrooms and locker rooms, because when you really dig into this opinion, yes, the holding itself does not apply to bathrooms and locker rooms and private spaces, but there is a roadmap in here, of how we need to be challenging, all of of that privacy violation, and what we need to be do to establishing that, because I think that's where a tremendous amount of the harm actually happens to our girls too.
Yeah, that was going to be one of my next questions. How does this reasoning reach bathrooms and private spaces? Because the bathroom issue is really the bigger issue than sports, because just every state, red or blue, is dealing with this question, because all girls, maybe not all girls play sports, but all girls use the bathroom.
Yeah.
All, it is just the bigger issue. And it's the bathrooms, the locker rooms, the changing areas. All the kids have to take gym class. Okay, that is required. That's like state law. And so if they're in a swim unit, and they have to change, and there's a boy that is changing with them or showering next to them, and it happens all the time. I don't want to even see here in the comments, oh, that never happens. It happens all the time.
All the
All the
time.
time. A lot of times it's not reported. I can tell you that we report a fraction of what we hear. The complaints that I get, a lot of the parents and the kids do not want to come forward, but they tell us about it. So you're only hearing the few that are willing to stand up, and I think that's growing, but it happens all the time. That is a bigger issue. And I also want to talk about compelled speech. I know this is really important to you, to Southeastern Legal Foundation. What about the compelled speech component of these Title IX dictates? Because when the schools or the school districts or the states say we're going to include gender identity in the definition of sex as per Title IX, what they're doing is they're writing non-discrimination policy that compels the speech of teachers and students to say the pronouns, to say that John is now Joanna, even though obviously they're not. You cannot change your biological sex. So what about these important issues that I think these
Yeah, a
are.
lot to unpack there, and I honestly don't know if I have answers to all of it right now, as to how we can use and build off of this particular opinion. But with the first point about the bathrooms and the locker rooms, yes, it's happening everywhere, right? I don't even have a patience for people that say it's not. We're actually we have a new Title IX complaint that we're filing tomorrow on behalf of a family, out there. I'll be able to tell more about that tomorrow, but whose special needs daughter has been facing a boy in the girls' bathroom, and the school just says, oh, wow. But, with respect to all of these, what we're really looking at, and I'm looking down because there's some good language that I was looking to try to find in here. But you're really going to be taking this opinion and saying, okay, is there a reason for states to say that boys can't be in girls' bathrooms and locker rooms? Well, if competitive fairness and a girl's safety on a field is enough, which it should be, then a girl's safety in using the restroom and her physical body should absolutely meet that constitutional standard. It's just going to be a matter of establishing that and working these cases through the court. And so what I hope we see is I hope that we see states, at least our red states, come out and make really, really clear legislation that not only says that boys can't play in girls' sports, but that boys can't be in girls' private spaces. And vice versa, that girls can't be in boys' private spaces. And then, of course, those laws might get challenged, but according to this, they should be upheld.
Yeah. Yes, that's really good to know. Now,
Yeah.
what do you think is the best part of this opinion? What is the part that matters 5 years from now? What is the
Oh
legacy
my
that
gosh, I have
B.P.J.
my
or their
highlighted.
men.
If I could show you, it's like highlighted and tabbed and
Yes,
everything as we're working through this. I mean, I really think there's two key parts. And I've said I was going to sound like a broken record, but the first is obviously that we have this definition of sex. It's the common sense definition of sex, both to Title IX and the Equal Protection Clause. Building off of Skermeti, which said that transgender gender identity is not a protected class under the Constitution. So really reaffirming that. And then there's a whole nother section that we haven't talked about where those on the left had been trying to use this case called Bostock. It's an employment discrimination case to say that that transgender was a protected class. They were trying to expand the holding there to Title IX. And the court makes it very, very clear that in Bostock, it was actually ruling on discrimination on the basis of sex, and that that's no different than what it's doing here. And so it cabins that opinion essentially, which again might be hard to conceptualize, but for those of us in the legal world who are representing all of you parents out there, it matters a great deal. So you asked for one, I gave you three, but it all comes back to that definition.
So I'm going to read my favorite passage right here. It's the concurrence of Clarence Thomas.
Yes, that's my favorite.
It says, men and boys with gender dysphoria are not women or girls, even if they believe they are. Sex is an immutable biological characteristic. It is binary, and man and woman, boy and girl are terms that correspond to adults and children of each sex. To use language to obscure reality, to show indifference regarding the truth, is to lie to the public and cause to retreat our fellow citizens as equals. Wow.
Yeah.
Wow. I think mic drop moment right there. I love it.
I know. And there's another great passage, and this one is less legal. And this is more of my mama bear kind of coming out for my daughter. It's towards the end of the actual opinion. And I'm not going to read it all because it goes on for about a page and a half. But it starts out by saying women and girls who play sports care deeply about all of those things. They obsess about them. Goes on to explain how they spend extraordinary time and effort to train in the heat in the morning, what their trophies mean to them, how that affects their friendships, their lifetime memories. And it just goes on. And I spend about every single weekend of my life at the softball fields watching all of this play out for my daughter. And it literally made me cry reading. I never cried reading it in a Supreme Court opinion. And I probably sound silly to some people, but if you have kids who are athletes, you know how much they pour into their sport and how much they obsess over it. And he really captured all of it right here. And so it just shows that, yes, we're talking about the legal part, but this opinion means so much to so many girls out there.
Yeah, it reads like somebody who has kids who have participated in sports, girls, or really listened, talked to girls who do participate, and what they were trying to say, the emotion. This is very emotional for them because when you pour your heart and soul into your sport and then something so unfair happens to you and you're told and you're gaslit and told, well, something wrong is something right, that boy is a girl, celebrate him. And it's just so jarring when you are forced, especially they're kids, whether they're in middle school or they're in college. I consider these are kids, these are girls, and this is not fair. And I wish more adult females that are athletes or were former athletes would stand up. But thank goodness for these girls in middle school and high school and their parents who are standing up and talking about their experience. Women just have to say no. They have to affirm biological reality. And I think that a lot are very grateful to see that the U.S. Supreme Court agrees with them.
Yeah, I mean, they see the problems in this, right? And the inherent unfairness. And I know we always teach our kids like, oh, don't say unfair, and like life's not fair. But this really is not, right? I mean, if you have a law that's passed to protect your ability to play in these sports and to have these educational opportunities, and then you have people coming in and robbing you of that ability, or if you're talking about bathrooms, robbing you of your privacy, of your dignity, that cannot stand. And to have the highest court in this country be strictly following Title IX, strictly following the Constitution, and yet recognizing what our young girls put into their sports. I hope that that gives all of them the confidence to keep going out there and fighting on the field, and we will continue to fight in the courts for them.
Now, my last couple of questions. The other side does not accept defeat. They are not going to say, "Oh, well, I guess we were wrong. Now the definition of sex has been defined. It's male, female, and the trans agenda, well, we're just going to leave it by the wayside." I mean, if you're watching the news, do you see the way they're going after their own? Even in
Yeah.
California, Anthony Weiner, like this is an aggressive bunch, and they have been thoroughly indoctrinated. They're not going anywhere. What do you see in the horizon in your experience?
I think they're going to get more radical, right? I mean, it's absolutely disgusting what you see. You can't even repeat what you see at some of these parades. I really hope that we see some of the bigger organizations continue to reject this, right? We've got the IOC, we've got the NCAA. I was talking to somebody about USA Lacrosse the other day. I wish that they would reject all of this because we are required to be part of that for our kids to play lacrosse. But I hope that we see more groups join the larger athletic associations in rejecting this. But I do think that those that want to push this radical agenda, they want to do it for nefarious reasons. They believe in this. They believe that our kids are theirs. It is sick. There's mental illness associated with this. And so I think that they're only going to dig in more, but the law is on our side. And so we have to stay diligent as parents. As they push forward, we're going to keep pushing back.
Yes. And what can a parent who feels powerless do? How does your organization, how does Southeastern Legal Foundation help parents and girls who feel powerless? Maybe this decision gives them hope, but they are in a situation with a school district in a state where they are bound and determined to reject biological reality.
Yeah, I mean, you got to be willing to stand up, right? And so you have to be willing as parents to stand up for your kids. I know it can be scary. You're afraid that they won't make the team. You're afraid that they'll be ostracized. I'm a mom. I get it. But we have to be filing more OCR complaints. We have to be raising the attention of these. There are so many people out there. Scarlett, you're one of them who helps raise attention and awareness when these things are happening on the ground. And then we have to be willing to use the court system. And so there's groups like ours, Southeastern Legal Foundation. We're a 501c3. We represent our clients completely for free. It's the privilege to get to do that every single day because of our donors, but we can only bring those cases if parents are willing to stand up. But reach out to groups like ours. There's other groups out there that want to help you. You just have to be brave enough to do it, which I know can be scary. I don't say that with the judgment. But if we don't stand up for our kids, no one else is going to.
100%. Well, Kim, thank you so much for coming on and clarifying some of this case and giving us that legal knowledge that we need. And when we're talking to other people, because I'm already in like a bunch of conversations.
Yeah.
With questions, here you go. There's some answers. You can provide some of that. This is obviously being recorded. We're going to replay this and we're going to make it available on our Moms for Liberty website. We're going to make sure that you have access to this recording so that you can listen to it, take notes, replay it. And we encourage you to read the opinion yourself, right? Like it's always a good idea if you're really interested, read the opinion yourself and be sure to stay tuned because we have a lot of collaborations in the future, right, Kim, with Southeastern Legal Foundation. What are some of the things that we're going to be doing in the fall as school approaches, and what are some materials that your organization is going to be providing to parents who have a lot of questions and need some answers?
Yeah, so we already have a number of guidebooks out there. We have guidebooks out there telling you all about your parental rights. We have one on Title IX, which as of today is outdated, but I would still suggest to go download it. It gives you some good advocacy tips and free speech. We have a new training series that we're rolling out that's going to be about understanding your public schools. So if you don't even know where to start, and most parents don't know where to start, right? When I'm saying to you, stand up, you're like, where do I go? How do I even know how to do that? It will kind of walk you through those basic tools from a legal perspective as to how to do that. A guidebook and a training program. And then we will have another one on PPRA and FERPA, so student privacy rights, coming out about mid-year. So lots of content. We're always available. And we will, of course, be at the Moms for Liberty Summit in Dallas, Texas in October.
Yes, and if you go to all of our social medias, you'll have ways that you can register. If you register early, there's discounts and all of that. But it's always a pleasure to have you on, Kim, and we're so grateful for Southeastern Legal Foundation and all that you do. There's going to be so many different collaborations and so many, we have a lot of opportunities for parents, for grandparents, even for kids to understand how to stand up for yourself and not be bullied into compliance. You do not have to, your speech does not have to be compelled. You have rights and you need to just understand them and be able to defend them yourself. And it starts with you. You can't look around for someone else to save you. You have to be the person you've been waiting for. So that's
Well
something
said.
I say all the time. Well, thank you, Kim, so much. I appreciate you coming on. And everyone, if in just a few hours, I'm going to be on with the Wisconsin Institute for Law and Liberty in another live, and we're going to talk about this case some more and just continue the conversations because I think everyone is intrigued and they want to know more. So thank you.
Thanks, Scarlett. It was great to talk to you.
Have a great 4th of July.
You too.
Bye.